Unlike most Western high courts, the US Supreme Court has a highly political character, with judges vetted and appointed for their political views. The jurisprudence of the court evolves as the political character of the court evolves. Trump administration appointments gave the court a conservative majority, and it was immediately clear that a number of keynote progressive precedents were likely to be challenged. One of those was University of California and Bakke, which had held that racial quotas violated the 14th Amendment protection of equality under the law, but affirmative action short of a quota system was permissible. Students for Fair Admissions is a conservative group supporting colourblind admissions to US colleges, where race is not considered at all. That's clearly one approach to equality. The other approach is to recognise that students from racially diverse backgrounds may struggle for reasons of historic disadvantage and to take this into account. Students for Fair Admissions challenged the admission processes at Harvard and the University of North Carolina. They focused on Asian American students who missed out on admission due to affirmative action policies. In reality, though, the details were meaningless. The justices would either overturn Bakke or not. The justices split. The 6-member majority said affirmative action violated the 14th Amendment protection of equality under the law. There seemed to be two key objections. First, the objection in principle against treating people differently according to their race. And second, the fact that Bakke was nearly 50 years in the past and that there seemed no end in sight to the need for affirmative action, which suggests that it is not correcting the problem that it's designed to resolve. The Chief Justice said, eliminating racial discrimination means eliminating all of it, and the Equal Protection Clause, we have accordingly held, applies without regard to any differences of race, of colour, or of nationality. It is universal in its application. University programs must comply with strict scrutiny. They may never use race as a stereotype or negative, and at some point they must end. Respondents' admission systems, however well-intentioned and implemented in good faith, fail each of these criteria. The early consequences of this decision seem to be, unsurprisingly, a reduction in enrolment among historically disadvantaged groups in America's finest universities. Whether this matters, and whether the judges got it right in this case, unfortunately, remains mostly a matter of your personal politics.